Hi, everybody. Thank you so much for joining us today. My name is Daphne. I am the program manager at Lisa's Care Connection. We have education pieces like this throughout the year. And today we have two great advisors, Joaquin, who is a financial and portfolio advisor with Merrill-Lynch, along with Ed Kinglet from Oak Cross Law Group. He is the managing attorney at the firm. And today they're going to be going over financial and legal planning for the future. This information is pertinent to everybody, regardless of age or regardless of, disease status or anything else like that. Lisa's Care Connection, we do primarily focus on the caregivers who have a loved one with Alzheimer's or dementia. But like I said, this information is important for anybody, regardless of their health, age, or things like that. And so in just a moment, we will have Joaquin here begin the presentation on the financial aspects of advanced planning.
Perfect. Can everyone hear me okay?
Yes.
Sweet. Then I will go ahead and share my screen. Daphne, please make sure I share the right one.
Yes, will do.
Perfect. All right.
Looking
All
good.
right. And then let me know when we are all good to go.
Okay, take it away whenever you're ready.
Sweet. So I just first want to start this off by saying thank you so much for attending this webinar today. And thank you to Bree, Daphne, and Diva for inviting me to speak about something so deeply important. I really appreciate the amazing work that Lisa's Care Connection does. I certainly know that my family and I really could have benefited from their help when we were taking care of my late grandma Mary when she was diagnosed with dementia a few years back. So the important life stage we're addressing today is caregiving. We're going to discuss the increasing need for caregiving itself, how it may affect you and the people you love, and of course, ways to plan and prepare for the impact. In my opinion, Rosalind Carter said it best when she said there are only four kinds of people in this world: those who have been caregivers, those who currently are, and those who will be, and those who will need them. The need for caregiving is evolving. In the past, life experiences, along with family social structures, didn't make the impact of caregiving the real challenge that it is today. But now, with major innovations, we are seeing four forces that are transforming the landscape itself. Longevity being the life expectancy that we expect to increase from age 79 to 84 between 2015 to 2050. This increases the prevalence of age-related support. Demography, the number of caregivers, is projected to drop by nearly half in 2050. So you can see that difference right there, causing a huge shortage in caregiving. Sociology, due to the changing size, shape, and distribution of families in America, 1 in 4 baby boomers are at risk of becoming elder orphans without relationships to help them with care. And lastly, technology, only about 75% of caregivers are using any kind of caregiving tech available in the market today. But as younger generations take on more caregiving tasks, the adoption of technology is expected to soar. So as you plan for you or your loved one's future, what is the likelihood that you're going to need care? 7 in 10 Americans turning 65 or older may need care for a prolonged period of their lives. And the increase in number of individuals needing care also affects the number of people who will need to provide that care. In 2023, caregivers of people with Alzheimer's or other dementias provided an estimated 18.4 billion hours of unpaid care, amounting to $350 billion contributed outside of health facilities themselves. Unfortunately, caregiving does disproportionately affect women. This includes wives, daughters, daughter-in-laws. 66% of women, almost two-thirds, are often the sole provider of many different types of care, which can look like physical care, care coordination, and financial care, which is what this presentation is going to focus on today. However, there is now some evidence that we're finally seeing the gap shrink in younger generations where men are taking on caregiving roles more often than their predecessors. For a woman caregiver who leaves the workforce, an average of $324,000 is lost in wages and benefits compared to the $284,000 for their male counterparts. And this doesn't even account for retirement plans like 401ks, HSAs, and other benefits. As an added point, they are often less involved in a financial planning conversation with both spouses. So there can be a disconnect sometimes between financial planning conversations and the true understanding of the caregiver role and what it feels like and means to be in there. This is why I cannot stress enough when I'm meeting with someone or some people how important it is for both spouses to be active participants in these discussions. Women often tend to put their families first, often foregoing attention to their own long-term future, only to discover later that they should have done more for themselves. Consequently, the average woman may have earned less at retirement, more than $1 million less compared to their male counterpart who did not have these same disruptions and time out of the workforce not being able to earn. Not even to mention the spending required as a caregiver, even if you have significant assets, is still very major. Before deciding to scale back a career or retire early to become a caregiver and take on that noble task, please consider the impact on your future and weigh all possible options available to you regarding your caregiving journey. Before the need arises, it's crucial to consider programs such as long-term care, disability insurance, and others. This may be available to you via an employer benefit package and have these discussions with your family on strategy to provide and prepare for the cost of long-term care itself. Now, regarding caregivers in the LGBT plus community, LGBT plus adults face very unique challenges in the United States regarding needs and challenges for care. More often than not, they are single and they may live alone, and they are also less likely to have kids. So instead, many communities within that community have their partners and friends who they really do consider their family of choice that provide them with all different types of support. However, these caregivers may not be afforded the same legal recognition and protection that some service providers may not think to include them because they're not a part of a traditional family. This is why most states have adopted the CARE Act, which requires hospitals to ask patients at admission whether they'd like to designate a caregiver. Most versions require a hospital to record the name of the caregiver, inform them when the patient is being discharged, and train them to perform any medical tasks needed upon the care recipient returning home. Because the difficulty that many LGBT plus caregivers face, they have had a hard time finding supportive healthcare and service providers. They might postpone seeking out the proper assistance and support out of fear of inadequate treatment. Now let's talk about finances, right? Financial caregiving is far more complex and nuanced than simply just paying for and contributing to a recipient's care. There are two primary types of financial caregivers. One, financial contributors, and two, financial coordinators. Financial contributors are the ones who pay for the cost of care of the care recipient. Financial coordinators are the ones who are actually overseeing and organizing every aspect of their care recipient's finances. This can look like paying bills, managing investments, preparing taxes, handling insurance, and monitoring accounts. More often than not, this is the exact same person. So financial caregiving for seniors is a significant reality. There are approximately 37.1 million unpaid caregivers in the US, which is 14% of the US adult population. That's a big deal. On average, 7 out of 10 of them are contributing financially and spend at least over $7,000 a year for things like prescriptions, home repairs, and professional caregivers, consequently decreasing the long-term savings for that caregiver that takes on such a noble responsibility. Moreover, a caregiver's financial security may be at risk because of the implications of caregiving are evident in ways beyond those out-of-pocket costs we just referenced. Nearly half of caregivers have experienced at least one of these setbacks due to caregiving. While it's most common to have reduced spending or dip into a savings account, nearly 1 in 5 had to cut down their own healthcare spending or reduce how much they are paying for retirement. 12, in fact, have 12% dipped into retirement savings, which can potentially incur taxes and penalties having to pay more. 12% take out a loan or borrow from somebody, 6% resign from their job, and 6% have to retire early. Few aging adults or caregivers are actually prepared, which can lead to conflict between their own care and what the family not just is willing to provide, but is also capable of providing. That's why, with preparation and hopefully planning, this can be mitigated. Only about 1 in 3 adults over 40 have money set aside for a version or some sort of long term care. Only 15% are confident they'll even have the resources to pay, and only 45% of caregivers and 45% of current recipients have even created healthcare plans. And 41% of them entered the role of caregiving suddenly, which I'm sure a lot of you guys can relate to. The caregiving phase is stressful and can be a roller coaster in many ways, as I'm sure it really was for my family. Once a health problem emerges, the stress goes up with an inevitable learning curve, just like anything, often where work and life adjustments have to be made and financial needs escalate immediately. So here are 3 long-term care options worth discussing. Selecting the right policy is driven by your preferences for coverage, and that focuses on long-term care, or that combines a policy with the flexibility to use the policy's value to provide the long-term care if needed. So we're going to walk through these briefly. The first option is traditional long-term care insurance. So with this, you pay premiums generally every year based on the benefits you select when you purchase the policy. If you stop paying the premiums, your policy will be canceled. You will not get your money back. It's also important to note that the premiums may increase. It provides long-term care benefits, however, if you should need them, and tends to have the most robust array of benefits themselves. This policy, however, does not have a cash value, meaning it's a use it or lose it scenario where if you don't have the money, if you don't use the money, then you simply lose the benefits. So the second option is a hybrid life insurance policy with a long-term care benefit rider. You may pay premiums over time or when buying the policy. Premiums, long-term care benefits, and death benefits are guaranteed. The amount of long-term care benefit can reduce the death benefit, however. A money-back guarantee may be available for an added fee. The return of premium may also have a vesting schedule and can be adjustable based on loan activity, withdrawals, or claim payments. There may also be tax implications. The long-term care benefits of this option are based on the face amount that you choose for coverage, plus the money that you invest. So they may be less robust potentially than a traditional long-term care policy. While a hybrid policy provides long-term care benefits, unlike a traditional policy, you don't use the long-term care benefits. What happens? Your beneficiaries actually could be paid a federal income tax-free death benefit. So a hybrid life insurance may work well for you if you want to plan for just in case, but also want the potential to set aside funds for your beneficiaries if you don't end up needing the long-term care. The third option is permanent life insurance with a long-term care or chronic illness option. Costs and benefits are based on how much life insurance you purchase. The various premium options for payment are available. Premiums and benefits may or may not be guaranteed depending on what specific policy that you end up choosing to do. Similar to a hybrid policy, any benefits are limited by the face amount of the policy and may be less than a traditional long-term care policy itself. Unlike traditional long-term care, this type of benefit does have a cash value. It provides a death benefit, but it also has a rider that provides that death benefit early if you need it to cover long-term care expenses for a permanent health condition. So permanent life insurance with a long-term care or chronic illness rider can be a good choice if your primary goal is to get insurance protection with a death benefit for your beneficiaries and you're concerned about the possibility of having to pay for long-term care benefits you might not use. Regarding Alzheimer's itself, there are so many Americans living with Alzheimer's and it's growing fast. Over 6.9 million people, and 1 in 9 age 65 and up that are adults live with Alzheimer's, and almost 2/3 of them are women. So those showing cognitive decline are often asked to complete something like a simple clock drawing test, where they can draw a clock and set the hands to a specific time, as you see here up on the screen. But for someone with Alzheimer's, even this basic task can be so difficult. And something this simple becomes challenging. You can only imagine how hard it is and feels to have to manage family, relationships, finances, and the other parts of life that do require clear planning and sound judgment. That's why making decisions as early as possible with all the right people, while good judgment is still a possibility, is so important. And then I'm going to click through these really quick because there are several cognitive decline areas that can affect different parts of your life. So it's crucial to catch these as soon as possible. While I'm sure everyone here is familiar with the warning signs, I did want to list out 10 of them to make sure you can identify Alzheimer's if something is unfamiliar. And while I'm sure this goes without saying, if you detect any of these warning signs in yourself or in a loved one, please consult a medical professional. Now, getting into the actual cost of Alzheimer's itself, right? A lot of families are not prepared for the big wave of medical bills that may hit. In 2024, it's estimated to have cost the nation $360 billion unless a treatment to slow, stop, or prevent the disease is developed in 2050. Alzheimer's is projected to cost nearly $1 trillion to American families. It's critical to ensure you have a strategy in place to manage this expense and plan for the what ifs in your financial plan or your strategy. So, where do I start, right? Having a plan in place is important to meeting your and your loved one's wishes and needs. So, having this discussion prior to you or a loved one entering this life stage enables a smoother transition and the ability to make appropriate decisions. And even if it's too late, then you need to prioritize it as soon as possible. The three major areas that we're going to review are family decisions, preparing for healthcare costs themselves, and of course, legal documentation. But before we get into all of those, I did want to highlight how important technology is to your caregiving journey. For caregivers who live far away or are juggling jobs, children, and care, new tech can be helpful in a number of ways to monitor someone's safety at home, even if you're not there. A couple great examples that I do want to touch on are telemedicine for quick clinical check-ins, fall detection or response technology, and different types of monitors to shorten time to treatment after incidents, and a shared care calendar with the family or caregivers to coordinate meds across everyone involved is very helpful. Now, talking about family decisions as you begin to prepare, consider making these with your family as early as possible. Speak with relatives about expectations everyone has for each other to develop an emergency plan so everyone is on the same page so things don't come as much of a shock. Identify roles, especially if the family is spread out across the country, across the city, across the state. Assess your own work obligations and consider flexible hours or remote work availability so you don't have to sacrifice earning years that could put you at a disadvantage. Determine where recipients want to receive care and by whom. Consider in-home versus care facilities, and if it is in-home, conduct home accessibility maintenance if it's needed. And also develop a plan to monitor and maintain your own mental and physical health. And I cannot stress this enough because it's just so important, especially in this day and age. Now, healthcare can be costly, and if the individual needing care hasn't developed a plan to pay these costs, it can impact both the recipient and the caregiver. By having a plan in place of how to pay for these expenses, it may help reduce the financial impact overall. Neither Medicare nor Medicare supplement plans fully cover long-term care. Medicare only covers a small portion of short-term rehabilitation costs. It doesn't cover long-term care. Medicaid might be able to pay for some long-term care, but in order to be eligible, you have to significantly spend down your own assets first. That's why it's important to look at all your options, whether that's private long-term care insurance, a home equity line of credit, or securities-based line of credit off of a portfolio, tax credits available to you in your situation, or health savings accounts. Regarding legal decisions, you or your loved ones should make sure there's a will in place and up to date to organize all documents. Arrange powers of attorney to make sure financial decisions are able to be properly managed if the recipient is no longer able to do it themselves. Arrange powers of attorney to be able to do that. Determine a healthcare proxy who is authorized legally to make important health related decisions for your loved ones through advanced directives like a living will or durable powers of attorney. Consult an estate planning attorney. We have the amazing privilege of hearing from Ed. He's a managing attorney at Crest Law Group. And in just a moment, he's going to discuss the legal decisions of caregiving in a lot more depth than this. And then, depending on who you speak to, whether they're an estate attorney about placing assets into something like a revocable trust and naming a successor trustee to facilitate financial management. So the key is to start early, hold a meeting with the entire family or anyone in the right circle, if possible, to develop a plan. These meetings should continue regularly as life is dynamic and changes all the time. And a caregiver's availability to provide care may very well change, and it's a lot of pressure to put on just one person. Make sure to revisit the care plan as well during these meetings to make relevant updates. Organize your finances. Caregivers should develop a written financial plan that's able to be adaptable to ensure that they have proper documents to coordinate care of a recipient's finances if that is necessary. All caregivers should build a strong support network. This can include family, friends, neighbors, caregiving professionals, and the amazing folks here at Lisa's Care Connection. This wider circle can help with tasks when needed, or simply to provide emotional support, which is more valuable now than ever. So this is going to end our presentation. I believe we'll have some time at the end for questions. If you have any questions specific to you or your loved one's financial situation, I believe my contact information will be listed at the end, and you can also get it from Bree or Daphne, and I would be honored to be a resource. Thank you.
Thank you, Joaquin, so much for your lovely presentation. I just want to quickly remind everybody that there is a chat feature and a Q&A feature below. If you do have any questions, feel free to submit them now or while Ed is presenting. So sorry about that, but this is Ed. He is again the managing partner or managing attorney at Oak Crest Law Group, and he's going to be going over the legal aspects of advanced planning. So Ed, take it away whenever you're ready.
Thank you. I thought that was my tech. I thought I pushed the button, so sorry about that.
No worries.
Is my screen correct? Very good. Okay. Well, thank you, Joaquin, for starting us off, kicking us off. And also thank you to Lisa's Care Connection, for inviting me today. I wanted to pause and I wanted to start with some gratitude. I get asked to speak to general audiences, and trying to put together general information. But today is special. Today, I was specifically asked to talk to people who are in a particular situation, specifically caregivers who are taking care of people who have mental incapacity, Alzheimer's, cognitive disease. And so I wanted to say thank you for doing what you do. Um, I can only imagine. I know that is difficult, balancing all sorts of things, whether you're working full time, taking care of a loved one, a parent perhaps, or even a spouse. I'm going to try my best to address some of the things that I think you should be considering, although it applies to the general population. I want to impress upon you a couple of key estate planning tools, documents, so that you can be prepared for the future. And one of the things that I'm going to be sensitive to is if you're not around and your loved one survives you, who is going to take over? If you're not around and your loved one survives you, who is going to take over? All right. So again, thanks to the team at Lisa's Care Connection. for inviting me. Here are the numbers, and I know Joaquin shared a bunch of numbers. The numbers here are such that most people don't prepare um, for estate planning. And actually, the number on the top from 2022 was better than it was prior to the pandemic. Prior to the pandemic, 80% of the American public did not plan. And if you break this down, it's about 47% have a will. I'll go over what's a will, what if you don't have a will. And then about 20% have a trust, which is the gold standard here in California with respect to assets. But essentially, if you add those numbers up, it's about 30% of people do proper planning. So if there's one thing I'd like to impress you in these next 20 minutes is to have some basic planning in place. Basic planning for you so that someone can take care of you. And then also basic planning so that you have some a backup plan for your loved one if it happens that they end up surviving you. I'll talk about the probate courts. I know this it's a word that a lot of attorneys throw around. What is the probate court? Why do we need a court? And how does the court function? This is definitely a trick question. Who needs an estate plan? Estate doesn't necessarily mean you have $1 trillion in the bank. It doesn't necessarily mean you have $20 million. It also can mean basic things like who's going to be making healthcare decisions for you. Yes, it has a lot to do with assets. If you own real property, if you have other assets that are 200,000 or more, there are things like trusts and wills to take care of assets, but there are also basic estate planning documents that are necessary to take care of you and your personal welfare. What happens if you die without an estate plan? So there are two categories. So this is assuming you don't have a will, you don't have a power of attorney, you don't have a trust. Depending on the asset, you might have already designated a beneficiary. Two very common assets are retirement plans as well as life insurance policies. Necessarily, when you set these assets up, or when you open a retirement account, the company will require you to designate a beneficiary. So it could be that if you pass away, it's going to be transferred by contract. The issue there is that you need to make sure that the individuals, the beneficiary that you have designated, is correct. What do I mean by that? If you set these up 30 years ago, you might have listed a parent, you might have listed a partner, you might have listed a best friend. And 30 years later, things change. People pass, relationships change. You might subsequently get married, you might have kids. So make sure you look at those to confirm that they are still appropriate. The other way that they transfer is through state laws. And so the case of James Dean, by the way, this happens to so many people. Prince, Aretha Franklin, Whitney Houston, people are not setting up an estate plan. And so what ends up happening is they pass away, they have assets like James Dean. He was very young, he was only 24 years old. He passed away in a car accident in California. And because he did not designate, the state of California designated or chose who his beneficiary was. So the good news is a lot of the times the courts get it right, and they've already passed these succession of individuals. So if you're married, your spouse, your kids, your parents, your siblings. In the case of James Dean, it can be argued that California got it wrong because by the time he passed, his mother predeceased him. He was not married and he did not have any children. And so the court gave everything to his father even though his father had abandoned him and his family when he was quite young. So, the moral of the story is the best person to be making decisions about where your things go is you. The best person is you. So, about 40% of people, 47% of people, I think, have a will. The difference with the will is that you actually get to choose who inherits, right? So James Dean didn't have a will. It went to the father. We have someone like Marilyn Monroe. She had a will and she gave 75% of her estate to her acting coach, Lee Strasberg. So the good news is the will allows for a beneficiary, but it all ends up in court. It all ends up in court. So a lot of people think that wills avoid court. If you don't have substantial assets, they can. But for most people in California with a simple home in LA County, it's like over $1 million, $1.5 million, depending on the zip code. So the will be probated. It'll go to court, and I'll explain what that is. There is an executor or a decision maker that's designated in the will who will take care of things like assets, debts, and distribute. In the state of California, it takes quite a long period, 1 to 2 years in some counties. Some counties that are busier can take up to 3 years, 5 years. And again, it depends on the volume. It's very expensive and it's purely public. So let's see if I can get this video here. So it's also very expensive. It's about 5 to 10% of the value. So if you have a home, even though there's a mortgage, they'll take $1 million of that 5 to 10%, up to $100,000. And again, California is divided by counties, right? And so we have a busy county. It might take longer than the average 1 to 2 years, sometimes 3 years, 4 years, 5 years. There was a time in LA County where we would petition the court and you would not get a hearing until 8 months later. So the court system is like the freeway system. It's the 10, it's the 405, it's the 101 at 9 o'clock in the morning. I grew up in California. I remember after college, I would get on the 10 freeway and it would be a parking lot. That is what the court system looks like. So the question is how to avoid probate, how to make it private. And so there are 5 ways, 5 popular ways. Number one, own property jointly with rights of survivorship. This can be done through a brokerage account with Joaquin, but more popularly, it's through the ownership of real property. Now, the caveat is so long as one person is alive, it is okay, right? So if you have 2 people, husband and wife or spouses, one passes, so long as it says jointly with right of survivorship, joint tenancy with right of survivorship, if one passes, everything will go to the survivor. However, if the survivor passes, then it would go to probate. So that would be a temporary solution. Number 2, complete beneficiary designations, life insurance, retirement. Sometimes it makes sense to put a backup beneficiary, a secondary beneficiary. I've seen even tertiary beneficiaries. That's because if the person in the primary position passes before you or with you, then they'll want to know who gets it as a backup. I have practiced law for 18 years, almost 20 years, and I have seen situations where they put minors as beneficiaries or they put parents who predecease the owner and it ends up in probate court. So beware, these are temporary fixes. You can also make lifetime gifts. Right now, the estate tax is quite high. You need more than something like 15 million to pay estate taxes. So some people that have substantial assets start giving away their gifts, right? You can do that on an annual basis and you can do that on a lifetime basis. And then finally, you use trusts, and all of these will avoid probate to some extent. All right, so planning for incapacity, and this is where I wanted to hit home for this crowd, is a lot of estate plans don't consider incapacity. A lot of clients, when they meet with someone like me, they think that they're healthy on a Monday and then they pass away quickly and swiftly and efficiently on a Tuesday, and that's not the case. Statistically, you will become incapacitated. You can become physically incapacitated and then ultimately mentally incapacitated. So you need some very, very important documents. It can strike you when you're older. There are some viruses that can bring it on if you are younger. One of the things that happens, which is unfortunate, is if you don't do this type of planning, you could end up in that same court that I referenced with respect to your assets. It's the same probate court. And so you always see this with some famous people when they have mental capacity issues. Britney Spears had to go through a conservatorship, even dealing with minor children. And so by planning for incapacity, you're leaving a set of documents in place so that if something happens, we'll know what to do. And so here are four examples of very important documents. Number one is the durable power of attorney. That is a financial document. It's stating that if you lose capacity, you've already designated someone to handle your finances so that they can access your investments at Merrill-Lynch, so that they can access your bank accounts, they can pay your taxes, they can access your safety deposit box, and then they can maybe even sell your home if that is appropriate. These next two deal with healthcare. The first one is a HIPAA waiver. The HIPAA waiver is a document that allows otherwise private medical information to be shared with a third party. And then you have the Advanced Healthcare Directive, which does three things. It is like a power of attorney, but it is for healthcare. So if you lose capacity, you are designating someone to make critical medical decisions and welfare decisions about you. Number one. Number two, if you end up passing away or almost passing away, excuse me, you also can comment on your preference for the end of life, whether or not you want artificial measures, or if it is incurable, irreversible, and risky, you can say that you want to pass away naturally. And then finally, the disposition of your remains, cremation, anatomical donations. These are extremely important because the best person to be making these types of decisions is you. And then finally, nomination of conservator. So we have people like Britney Spears that I referenced. Her father was able to be her conservator. It turned out that he was probably not the person that she would have chosen had she filled out a nomination of conservator. This is the case where we do have to go to court and we need to appoint someone officially to take care of you as well as your finances if it comes to that extent. In the beginning slide, we talked about blended families. So let me just talk about this conceptually. And I know Joaquin referenced this. Blended families can be complicated in the sense that you could be in a non-traditional setting where your partner doesn't have the same rights as your relatives, for example, or you could be in a relationship, a married relationship, where your spouse is not the parent of your children. And so in any blended family situation, you want to be particular, you want to be specific because your kids, if you pass away, are not the children of your spouse in the blended family. And it could be that your spouse doesn't have the same priority or the same disposition as you are. And so I grew up with the Brady Bunch. And my example is if Mr. Brady passed and Mrs. Brady survived, would Mrs. Brady disinherit Bobby because that is not her son? Would she instead show preference to the girls? Would she give everything to Marsha, for example? And so in a blended family situation, the challenge question is if you're not around and your spouse survives you, what are some of the things that you'd like to carry out? And again, this is a complex topic. It necessarily involves the collaboration of multiple professionals, someone like me, someone like Joaquin, right? There are asset classes like life insurance that make absolute sense in a situation where, for example, you have a life insurance policy that pays to your children, and then your spouse can remain in the home. This is a great slide about how trusts work. So let me see if I can put this on. And so the trust is an agreement, and you happen to be three people all at once. You're the owner, obviously, but you also are the manager, a trustee, and the beneficiary while you're alive and healthy. You are all three. And the reason why the trust is so powerful is you've decided critical questions about the future. So, for example, if you get sick, you've already figured out who the trustee is after you. You are choosing this person, not the judge, not a random person. So, arguably, the person that you choose is the best person, right? So, let's say you chose your son to be the manager. Well, your son can step in and manage the assets. While you're alive, you remain the beneficiary, but if you pass away, you've already decided who the beneficiary is if you don't use all of your assets. So let's say you have $2 million, you leave behind 750,000, and you decide to give 50% of it to Lisa's Care Connection, and then the other 50% to your godson, as an example. And the reason why no one has to go to court in a trust is because you've figured all of this out. All of the assets are properly titled. You've designated the appropriate person to take over when the time comes. No one needs to step foot in the courthouse. The difference between wills and trusts, wills are easier, wills are more affordable, but that's usually because the trade-off is that if you use them, they end up going to court. So they end up becoming more expensive in the long run. Versus a trust, there's more work in the beginning. You have to set it up. It's more expensive, but in the long run, it is more efficient and less costly, right? That's the slide between the attorney, myself, and the financial advisor working together to make sure that we have dotted the I's and crossed the T's. And so really the idea is setting things up so that when the time comes and the transition happens, you are no longer a burden, or you will not be a burden to the family. And so that you can efficiently go through life having the peace of mind that you have protected the assets, you've designated the people who you trust, the people who you love to make critical decisions for you. I know that there is a section on contact information. We'll get to the questions in 1 second. So let me just make sure. Yeah, there is a 800 number for my office. There's also a QR code for those of you that are fancy, 800-631-1881. And I think now we can transition to the questions if that's okay. So let me end this. Did I do that right? Let's see here. All right.
Okay. Welcome back, everybody. So the first question that we have is, how do you best choose a financial or legal advisor?
Let's try it. What is it?
That's a great question. Ed, do you want to take the legal advisor and I can take the financial advisor?
Yeah. So I think the way I've been practicing law is you want references, right? Gone are the days where you are opening up a yellow page or a white page, I forget what it's called, and then just cold calling. I'm of the opinion that they should be referenced. And so a good place to start is your current team. So if you have an accountant, for example, talk to your accountant. I'm sure your accountant knows several above average referral sources. That is my old-fashioned question. Joaquin, you clearly look much more younger than me. And so the Joaquin, answer to that is, there's a lot of social media and there's a lot of TikTok and there's a lot of, people talking. So the person that you choose, make sure that they're well referenced. Make sure that they play well in the sandbox. Particularly for estate planning attorneys, we don't like to play well in the sandbox. They train us in law school to be bulldogs. Let's face it, I'm not fighting. There is no litigation. There should be no litigation. And so make sure that the attorney will work well with your financial advisor, will work collaboratively with your accountant, because as you can tell from my presentation, it's law mixed in with assets, mixed in with taxes, and the three of us need to be friends.
I agree. Basically, to kind of echo what Ed is saying, is a big portion of how my business works and the type of clients that I work with. A lot of them come from referrals, whether that's friends, family, an accountant, an estate attorney, a nonprofit. It's all about trust. Like not to make a pun about trust, like we're just talking about, but that's really what this is all about. So whether that's someone that you feel connects with you and is an extension of your family, it makes everyone feel comfortable is the main priority. And then taking it a step back to when you're looking for financial advisor, estate attorney near me, a lot of these things you could just get pushed with a bunch of people that are promoting ads. So you really want to focus on looking into them, whether what their website or social media says, the types of people they work with. Do they specialize with a specific group? Have they worked with a family caregiving before? When you're interviewing a financial advisor or an estate attorney during a Zoom call or an introduction, I think it's really important to be asking questions that pertain specifically to your needs, their experience with your needs, and really